Now call the third case on this morning's docket, case number 117035, Michael Creasy v. Kansas Department of Revenue. While counsel are taking their seats, I might mention typically for about the last 4 or 5 years, our proceedings have been live streamed online so that people watching around the world can see what's going on. I've been notified that because of problems with an outside vendor, that has not been happening this morning. It will continue through these arguments. However, good news for lawyers who like to watch themselves on the computers. We are capable of archiving those arguments, and so you can enjoy it later. Please proceed.
May it please the court, the petitioner, Michael Creasy, appears by and through counsel Jay Norton. And Chief Justice, I'd like to reserve 3 minutes of rebuttal time if the court would allow.
3 minutes is granted.
This is another administrative driver's license hearing case from Johnson County, Kansas, where a trial was had in the district court, and the district court judge made certain findings on the issues raised by the petitioner, Mr. Creasy, and we appealed to the Court of Appeals and then petitioned for review from the Court of Appeals decision, which was also adverse to Mr. Creasy. So that's what brings us here today.
Before you get started, real quickly, what I tried to ask the last case, why wasn't this strict compliance with service? When you handed it to him, he had control over it. There's no indication that he was ever denied possession.
Right. So I'm trying to remember specifically the evidence in this case. I think there was some testimony that that the document was presented to him in some way, and I can't remember whether he took it in his hands or...
He had it in his hands, was reading it for a while. They had, in fact, I think that's why the first intoxilizer did not have a reading, right, because he was reading his papers.
Right.
That was set down on the bench next to him, and after the second and third test, he got up, had a problem, got up again,
right,
and that then it was put, he was given a summons instead of arrested because he's going to the hospital, and that was put with his stuff to go with the EMT. And so why wouldn't that be strict compliance with personal service?
Well, the form that was given to him prior to the breath test or during that procedure would have been the DC-70 implied consent advisories that say what happens if you do or don't take a test. Yeah. After the testing procedure is completed, whether the person fails or refuses, then the officer fills out the DC-27, and the statute says it shall be personally served by the officer on behalf of the Department of Revenue. And so
but
the question
the evidence
is what
is that it was handed to him.
That's what I was trying to remember, I don't.
If the evidence
Right.
is that we can look in the record, we can nail that down. If it's
Right.
handed to him,
Right.
and ends up in his belongings going in the ambulance to the hospital, why isn't that personal service?
Well, so my position on that is that personal service means what the civil statute, KSA 60-303, says that it means. There's a Court of Appeals case that says that. I don't know whether this court will follow that or not. But personal service means personal delivery. It means a transfer of possession of these documents from one party to the other. And the requirement of strict compliance with personal service would avoid the issues that we see in all of these.
But how in this case, how would the officer have strictly complied with it, with your notion after having handed the document to the driver?
He would have handed the document to him and let him keep it, instead of taking it back and saying, you'll get this later.
That I don't think that's the evidence here, is it?
I believe that is the evidence, that he handed it to him, and or that if the evidence is that he handed it to him and that he held it for some period of time, and then it was taken back by the officer, which is what I think happened, and it later was put into a bag that they said, this is going to go out to the hospital with you, and it rode in the ambulance with him. I think this is a lot more questionable case about what constitutes service under these particular circumstances. But requiring strict compliance with the personal service requirement that's clearly stated in the statute would avoid what we see in the unpublished Court of Appeals cases that have addressed this, where they merely put it in the person's property bag, which they get when they're released from jail, whenever that may be. Is that personal service or is it not? There's one case where they touched the guy on the shoulder. So there's these games where we try to do the least we can do to effectuate personal service, but it's not really personal service. In any other type of lawsuit where one party is suing another, or in a divorce case, you wouldn't just run up, touch somebody with the paperwork, and then the court would say, yeah, they were personally served and we have jurisdiction over them at this point. And you get to the issue of if I understand the state's argument, is that, well, if the guy got it somehow at some point and was able to request a hearing, then isn't that, good enough? And my question on that would be, well, what if they just mail it to him? Even though the statute says it's got to be personal service, if they mail it to him, the guy gets it on the 13th day and scrambles in time to request a driver's license hearing, can he complain about the lack of personal service? I think following the clear and unambiguous wording of the statute, it eliminates a lot of questions, makes the law clear that the officer has to deliver the form to the person. And there shouldn't be any impediment really to them doing that, at least in most cases. As far as the rest of the facts of this case, the video in this case is important. It's dramatic. It does show Mr. Creasy collapse. He's unconscious. He has an obvious seizure. And no one disputed that medical condition was legitimate.
Well, how do we view a video of either validating or not validating an officer's impression or the district court's impression? How is it that we should look at that? I would say that in viewing the video, that the officer who was completing the testing was skeptical about the medical condition, especially as time went on.
From the video?
Yeah. So do we look at it from just our point of view as to what we think the medical condition is? Do we give deference to what the officer impressions are? How is it that we look at that?
I think you have to give deference to the district court's finding and determine whether there was substantial evidence on which the court could make the factual findings that it made in this case. There's some conflict in the officer's testimony in that he says, well, I think that he was playing a game and intentionally not blowing. On the other hand, he says he's having a legitimate medical condition for which I called medical people to respond before they ever talked about the breath test.
But he has to do more than just say he had a medical condition. He has to tie that to his inability to provide a sufficient sample. Right. And, I'm assuming there were some people with asthma or a history of asthma that can complete the test. And so it was his burden to connect the dots between his seizures and his medical condition and the inability to provide a sufficient sample. And I don't see in the record where he provided that, any proof of that. The fact he provided a doctor's statement that says, yeah, he has a history of asthma. But how is that sufficient to establish that? And the doctor didn't say, which would have precluded him from blowing in an Intoxilizer 8000 or whatever. So what was the district court, base it on? other than, well, gosh, he had a seizure and he had asthma, so surely that's why he couldn't do it. But that isn't our standard, is it?
Well, my position is that you've got the medical certification or certificate that says he has asthma and has a prescription for it. And then you have Mr. Creasy's testimony where he described his history and what was happening on that particular night. And then you have the video, which my position is corroborates his testimony. And you have the officer's testimony that, well, sometimes he was faking and then sometimes he wasn't. And it seems to me you can't have it both ways. That's about the best I can do with the evidence that we presented in this case was for Mr. Creasy to testify and for us to have some medical documentation that would support that, and then there's the video evidence that speaks for itself to whatever extent that it speaks.
Just while we're talking about the test refusal, just to clarify, below you had raised the issue of rescission.
Correct.
I don't really see that you've carried through on review that you're arguing rescission. Or was it your intent to ask for a review of that?
I believe so. I believe that I asked the court to review all of the issues in this case. I think that the basis for the petition for review, at least I thought, this court would be more responsive to the $50 application fee and some of these other issues for which the law is unsettled or at least arguable. The law with respect to rescission is fairly settled, so I don't think that I briefed it or included it in the petition as far as argument.
If it's there, how is that impacted by the offer of a blood test?
Well, so the district court judge found that the offer of the blood test did not comprise any part of the implied consent procedure. That if he refused the test by submitting 2 deficient samples and then was personally served, as the court found, that concludes the implied consent advisory procedure. And then this later request for a blood test, there were no new advisories provided, there were no new forms provided, the court found that didn't comprise any part of the implied consent procedure, which was
wasn't the offer of a blood test and took place several times during the that evening. I'm going to give you a break here. You've refused, but given the condition, you can take a blood test. And he did it several times, even when he was in the ambulance, saying you can do this now, and then we'll forego this refusal kind of thing. Give you a break kind of. Wasn't that the spirit of the blood test? Not to go through any implied consent initiation, but just to say, I'm going to extend this here and kind of cut you a break.
Yeah. The officer's testimony was that he offered him a blood test 2 times. Once as he was laying on the floor right after the seizure.
Right.
And then, which you can see on the video.
Right.
And then the officer testified that once he was loaded in the ambulance.
Yeah, that was on the video also. At least.
That he offered him another chance to take the blood test. So, what the spirit of the officer, what his intentions were, I think he wanted a test.
Well, that's what he said was his motivation.
Right.
He wanted that he's going to, rather than have a denial.
Right.
Which would result in a suspension, we're going to allow this stuff.
Right.
Was there, the other question I had was he obviously was taken to the emergency room after this. Was there any emergency room or medical reports as a result of that was introduced?
Not that were introduced into evidence.
Nothing.
Nothing from the hospital. There was some testimony from Mr. Creasy, but not any documentation. If there's no other questions, then I'll sit down. Thank you.
Do we have any more questions? Thank you, counsel.
May it please the court, I'm Assistant Solicitor General Dwight Carswell on behalf of the Department of Revenue. The Court of Appeals correctly rejected Creasy's facial challenge to the administrative hearing fee. The U.S. Supreme Court has never held that these fees are categorically unconstitutional. In fact, Logan v. Zimmerman Brush indicates the opposite, that they are consistent with due process in appropriate cases. Even in Bodie v. Connecticut, for instance, where there was a problem with the fee in that case, the court didn't strike it down across the board, just as applied to the individuals there. So at most, all that's required is a waiver for indigent individuals. So there's no facial problem with the fee. Turning to the DC 27 issue, yes, the facts, the video there, it's the Officer Rolf's video from the 50-second mark to the 2-minute and 18-second mark clearly shows that he's being handed the DC 27. He takes it. The officer's explaining, here's what this is. It's talking about the DC 27. He reads it for a while, sets it down beside him. Then yes, later he has a seizure and it's gathered up and put with his property. But he personally received that form. So there was personal service, strict compliance. There's no need to even get into substantial compliance here. Although again, in the last case, the state believes substantial compliance should be sufficient. On the DC 70 issue, there the Court of Appeals in a prior case dealing with an earlier version of the DC 70 held that the DC 70 did not substantially comply with the statute because it didn't draw a distinction between preliminary screening tests and evidentiary test. So the DC 70 was subsequently amended to use that phrase, evidentiary test, the very phrase that the Court of Appeals used there, and that this court, in fact, has used several times to describe the test in question. And that is an accurate term, unlike the preliminary screening tests, which are typically not admissible as evidence. There's a statute that only allows them in very limited situations, and therefore they can't be considered evidentiary tests. The evidentiary test is what we're talking about here. And so the form substantially complies with the statute. In any event, it made no difference in this case, as in the last case, he refused the test anyway. So there's no reason to suspend the driver's license proceeding. Regarding the failure to provide an adequate sample, the district court found that was not due to a medical condition. That finding is reviewable for substantial competent evidence, which is a deferential standard, and it definitely is supported by substantial competent evidence. Although Creasy claims that says that he has asthma, he provided evidence of that. There's no indication that at the time he was having problems with asthma. He was having other medical problems, which they initially believed was the officer and then the responding paramedic thought it was probably a panic attack due to his being arrested. But when the paramedic was talking to him and running the test, said the paramedic recognized that he had asthma and said, well, your breathing stats are at 100%, and said that several times. So the paramedic didn't seem to indicate asthma. Creasy never told the paramedics that I'm having an asthma attack. That seems pretty significant that if he has asthma and thought that's what the problem was. He didn't even mention it at the time. In addition, Officer Rolf, who himself testified that he has asthma, and it didn't appear to him that Creasy was having an asthma attack. Again, he thought it was a panic attack prior to the test refusal. But then by the time the paramedics left, Creasy had calmed down quite a bit. He was sitting down, and Officer Rolf's testimony was at that point, he appeared to be breathing normally, except when he was trying to blow into the test. And therefore, the officer believed that he was refusing intentionally to provide an adequate sample rather than due to any medical condition. But even if Creasy did have some sort of medical condition, he hasn't provided any evidence, as Justice Johnson was getting at earlier, that shows that his medical condition left him unable to provide an adequate sample. There's just no evidence on that. And in addition, he did refuse the blood test. The officer, as Justice Rosen was noting, said, I understand you're claiming that you just can't provide an adequate sample, so I'll give you a break and I'll let you do this blood test instead. And he still said, no, I don't want to do that. So that provides additional support for the fact that his breath test inadequate sample was intentional. And that can be used against him, although he says that there's some sort of constitutional problem with that. He doesn't cite any authorities. The U.S. Supreme Court has held that doesn't violate the Fifth Amendment to use a blood test refusal as evidence against someone. There's no reason it would be different here, especially in a civil case, unlike a criminal case. So overall, and then I guess the final point is, even if there was some medical condition, he also has the burden of showing that it was unrelated to the ingestion of alcohol, and there's no showing on that point either. So for all those reasons, the district court's finding is supported by substantial competent evidence.
What's your position on the rescission issue?
I don't believe that's before the court. It wasn't in the petition for review. It wasn't briefed before this court. I think he's waived that issue.
What if we disagree? How would you argue against that?
Well, I'm not super familiar with the issue because it wasn't in any of the briefing, but again, the district court rejected it, and I think that's supported by substantial competent evidence. He blew into the toxilizer 3 times. He was offered blood tests. There's no indication that he changed his mind.
I didn't understand that. I understand there were 3 tests. The first one was started but timed out.
Yeah,
And the second 2 were insufficient samples.
that's correct. Yeah, there were three breath tests, attempted breath tests. The first, I think he just didn't
Well,
blow
the first
in.
one wasn't attempted. It was started while he was still reading, was my understanding. So there was no attempt to put
Okay.
air into the, so you can't hold that one against, that was the officer's premature starting of the machine.
Well, there were at least 2 then. I mean, the officer attempted 3 times. Maybe he didn't try that first time, but he at least pretended to blow into the tube twice, and both times yielded an inadequate sample. And then, based on the officer's observations, it appeared that he was intentionally refusing. And then he declined the blood test twice. So,
Counsel, I think in the first case argued this morning, in which I believe you were present, a question was asked about our standard of review for whether the officer had reasonable grounds to believe. And we had some discussion about that. I don't know if that precise question was posed to you or opposing counsel in the Meats case.
I don't believe it was.
And so this is your opportunity to tell us in this third case this morning what your view is on that issue.
Sure. Well, on the particular issue of the test refusal, that's just a pure factual finding, is whether it was caused by a medical condition. There's no real legal issue there. It's just whether the district court's factual finding that no, this wasn't caused. You haven't at least shown. You haven't made a burden of showing that this was caused by a medical condition that left you unable to provide a sample. So that's just reviewed for substantial competent evidence. Now, ultimate legal conclusions, like reasonable grounds, those are, of course, reviewed de novo by this court. So in the first case, I think the ultimate legal question is de novo, but here it's just a factual question. I don't know that there's any legal dispute about the appropriate standards.
And when you say obviously it's a legal conclusion, what authority do you have to support that?
Well, I mean, reasonable grounds, now we're talking about a different case, but in that case, I mean, reasonable grounds is a legal conclusion. So anytime there's a review of probable cause or reasonable suspicion, again, factual findings that are tied to that are reviewed for substantial competent evidence. But the ultimate legal question about whether those findings meet the legal standard, that's a legal question.
So our review would be bifurcated?
In that first case, yes. Here, I believe it's just purely substantial competent evidence.
All right,
So-
thank you. Any further presentation?
I don't believe so, unless there are any further questions.
I see none. Thank you,
Okay,
counsel.
thank you.
I really don't have much to add or say that hasn't already been said here today. I don't believe so. I'm happy to try to answer any further questions, but other than that, don't have anything.
Do you
else to
agree
add.
that that's the correct standard of review that we just went over?
On a reasonable grounds type question? Or?
No, on this case. Substantial competent evidence is really not a legal finding. There's not really a legal de novo review in this particular case.
I think that I think the case law. I think it's maybe Call versus Kansas Department of Revenue that says whether a refusal has occurred, whether a person has refused a test, is a question of fact. And so I don't disagree with the state of Kansas on that issue, that it would be reviewed for substantial competent evidence.
I'd like to double back to the same question I asked opposing counsel, and that is on that issue of whether reasonable grounds exist to ask for the test. Do you have a position you can share with us on that standard of review?
I think it's a bifurcated standard. This is my best guess, that you review the factual findings of the court for to determine whether there was substantial evidence for those factual findings, and that then the legal conclusion is de novo.
Whether reasonable grounds exist or in other circumstances, as opposing counsel suggested, probable cause determination, reasonable suspicion determination. Is that what you're saying?
That's what I'm saying. Yeah, right. The same way that the court reviews a like a suppression issue or something like that, I think.
All right.
That's my best guess.
Okay. Do you have any further presentation for us?
No, thank you.
Any more questions? Thank you, counsel. We thank you both again for your arguments this morning. The court will take this matter under advisement.